Hello, and welcome to Dorsey and Whitney's Bank Counsel Roundtable on releasing third-party certainty in bankruptcy. I'd like to introduce Tom Kelly, a partner in Dorsey's Finance and Restructuring Group. Tom?
Good afternoon, everyone, and welcome to our not quite St. Patrick's Day edition of the Bank Counsel Roundtable. As Rima mentioned, we will be discussing third-party releases in bankruptcy. And our panelists this afternoon are Sam Cohn, a partner in our New York office, and Rachel Stoyan, an associate in our Palo Alto office. We are going to modify the usual format a little bit today in that we're going to ask people to send in their questions during the presentation by chat mode, and I will be monitoring that and interrupting the panelists when I see a question that I think they ought to address for the whole group, or when I have a question that I think they should address for the whole group. So with that, thank you for joining, and I will turn it over to Rachel.
Thank you, Tom, and thank you everyone for joining me and Sam, Tom today. Have up the housekeeping slide. There's a tweak to the Q&A. Please feel free to submit questions in the chat. Tom will be monitoring it, interrupting as he deems appropriate. And materials, you should have received them, but if you didn't, go ahead and just email dorsey@dorsey. And that's also, you'll return your attendance form to attendance@dorsey.com for CLE credit. So what are we going to be discussing today? Third-party releases in bankruptcy. We're going to start with a bit of an overview of who gets released in bankruptcy and what types of releases there are in bankruptcy. Then we're going to turn to third-party releases more specifically. What does the bankruptcy code say? What do the courts say? Get into the nitty-gritty of consensual versus non-consensual, which is where you find a lot of differences of opinion. And then we're going to turn to recent developments. There's pending legislation in Congress, non-debtor release Prohibition Act of 2021, as well as three very recent decisions just since December, February, that came down on this issue that we're going to touch on. So with that, I'm going to pass the baton over to Sam.
Thank you, Rachel. Hi, everybody. So we're going to get into the next slide, which is slide 5. Who gets the releases? Typically, of course, the debtors do. And importantly for this group, the lenders and the bank agents and indenture trustees. And it's not only the post-petition debt lenders or bank agents, but often the pre-petition lenders and bank agents and indenture trustees receive these releases. Other plan funders you may see get releases as well, and people know about the Purdue Pharma case where the Sackler family is now funding a plan to the tune of $5.5 billion. They recently raised it, and Rachel's going to talk a little bit about that, and what the status is in the Purdue Pharma case. There is also a number of constituencies that receive releases that are not on this slide number 5, and those are like major settlement parties. So, for example, if you have, if the case includes parties that have significant and substantial claims against the estates, and then those claims are settled through settlements in the plan, in the Chapter 11 plan. Often those settlement parties may also receive releases. And we could go to the next slide and we could start talking a little bit about, there are 3 major types of releases. The first part of releases is the debtor release. Those are releases of claims that the debtor, the borrower, could bring on its own, and any other claims that would be derivative of the debtor's claims. So this is the debtor releasing their own claims against third parties, and those are pretty non-controversial types of releases, and you'll see them in every Chapter 11 plan. The next section or category of releases is exculpation clauses. Exculpation clauses are supposed to be only releases of claims of acts that occurred during the bankruptcy proceedings. And that's why they're called exculpation clauses. And they're supposed to be only for fiduciaries of the estate. Over the years, Chapter 11 plans, debtors, and parties in interest have enlarged exculpation clauses to include many other parties, not only those that were retained under the bankruptcy court. The United States trustees in the various different jurisdictions have now acted to limit some of those exculpation clauses. We'll talk a little bit about the new congressional legislation that includes some of that, and some cases that we were involved in very, very recently, this past January and February, that limited exculpation clauses as well. The next slide, slide 7, this is the one that we're going to be talking about most. These are third-party releases. You'll see them in almost every single Chapter 11 plan. And that really includes third parties, not other than the debtors, right? It includes releases of claims against lenders, bank agents, and other third parties. And sometimes the third party releases are almost mandatory, whether the releasor or the releasing party is the releasor, even knows that they're going to be releasing third parties. And that's why they're called third party releases. And that's why they've become very controversial of late, until the Purdue case, really. There was no real litigation or controversy. However, there were cases, and we'll talk about them, in different jurisdictions treated third-party releases differently. But by and large, most of the jurisdictions allowed third-party releases in some form. And we could talk about a little bit more about the benefits of releases on the next slide. And why are third-party releases beneficial? Why? And one of the main reasons is that let's just take Purdue Pharma as an example. With whether however you view the releases of the Sackler family, and Rachel's going to talk a little bit more about the background of the Purdue case and the appeals that are happening now in the Second Circuit. But what's going to happen is that claimants right now, if these releases are ultimately approved by the Court of Appeals, the claimant pool will be able to have a $5.5 billion pool of recovery, of potential recoveries for their claims. That's a lot of money. And the Sacklers are committing that $5.5 billion only to get a release where they'll be finished with all kinds of litigation. Of course, this is really, there's a lot of litigation, a lot of controversy. Attorneys general and states are not everybody's agreeing to it. Even recently, there was as recent as last week, or as yesterday, the court approved another 8 states to sign on to the to the settlement for another $1 billion. But there's still a lot of objections to it. But why is it good? It also allows for a mechanism for parties to settle. And it doesn't even have to be a Purdue Pharma case. It could be new equity, old equity, for example, in the airline cases in Avianca. A good portion of the old equity owners are committing new equity, and they're getting increases. And so that's another way to settle litigation without third-party releases. It could really devolve into really protracted litigation, and that's why over the years third-party releases were very, very popular. And I think Rachel is going to continue the discussion and tell us about what the bankruptcy code says and does not say about third-party releases. Go ahead, Rachel.
So as Sam hinted at there, the bankruptcy code actually does not specifically address third-party releases anywhere within its many pages. It's a comprehensive code, but it does not expressly address third-party releases. There is a provision, section 524E, that provides that discharge of a debt of a debtor does not affect the liability of any other entity on, or the property of any other entity on for such debt. So that provision essentially says the discharge of a debtor isn't automatically going to discharge anyone else of that liability. And we're going to get into how that provision is interpreted by some courts, because there is a lot of disagreement on its impact, if any, on third-party releases. And then there's also a provision worth noting is section 524G, which was enacted in 1994 in response to the asbestos bankruptcies of the 1980s, and particularly the Johns Manville case. In that case, the bankruptcy court exercised its inherent authority to approve a plan that involved a channeling injunction, which essentially required all of the asbestos related claims to be channeled into a trust and have them dealt with that way. And then thereafter, all claims to other parties, the debtor, third parties, particularly insurance companies, those claims were all released. So if you were an asbestos claimant, you had to seek recovery from this trust. Congress thought this was a great idea, it seems, and essentially codified the Johns Manville channeling injunction into section 524G. That's a provision that does allow non-consensual third-party releases, but it is expressly limited to asbestos claims. So the question then is, do these provisions, 524E and 524G, limit the use of third-party releases outside of the asbestos context? And as we'll see right now, there's pretty vast disagreement among the courts. A majority of the courts have concluded that non-consensual third-party releases may be approved in bankruptcy pursuant to their inherent authority. Indeed, after the asbestos cases, courts started doing similar channeling injunctions in a variety of cases, from in mass tort cases, got your IUD cases, securities fraud, injuries, all the way up to more recent things like wildfire victims, opioid injuries, and sexual abuse victims. So you can see here, there's a pretty extensive list of circuit courts that have looked at the issue and said, in unusual or very unique circumstances, non-consensual third-party releases are acceptable. These courts apply a variety of factors in determining both whether it's sufficiently unique and whether it's appropriate in given circumstances, such as a substantial contribution of funds, whether the claims are actually being channeled and given treatment in some way, whether the affected creditors consent, and whether the proposed releases are fundamental to the reorganization, kind of a but-for. Like in the Purdue Pharma case, the Sacklers say, I'm not giving my $5.5 billion unless I get this release. So it kind of all falls apart. So that obviously is a pretty big factor for these courts. I will note that the Second Circuit is on this list that have approved non-consensual third-party releases, but only in more of a dicta type of way. The Second Circuit's Metro Media decision says that they would be permissible, may be permissible in certain unique and highly unusual circumstances. And as we'll see when we get back to the meat of Purdue at the end of this presentation, the district court in Purdue concluded that was not enough to rubber stamp the non-consensual releases in Purdue. I just wanted to kind of make that caveat, keep that in mind, that it looked like they were okay in the Second Circuit really up until this past December with the Purdue decision coming down. And as Sam indicated and I was highlighting, these releases have become kind of par for the course in larger Chapter 11 cases where non-consensual or deemed consensual releases are in almost every case. And that in turn has resulted in the drawing a lot of negative attention with the Purdue Pharma District Court judge aptly saying, when every case is unique, none is unique. So there's a bit of a blowback, and we'll get into that at the back end of this presentation. Now, there are 3 circuit courts that are always pointed to by courts and scholars as saying third-party releases are not acceptable, and that's the 5th, the 9th, and the 10th Circuit. These courts, all 3 of them, have issued decisions at the circuit court level looking to Section 524E, which says the discharge of a debt of a debtor does not discharge the debt of a third party, to say third-party releases are not allowed in bankruptcy. But if you take a look at the lower courts in each of those circuits, the lower courts acknowledge this precedent, but say, but if we have consent to the release, then it's okay. So in JCPenney, you've got third-party releases approved in their plan back in December 2020. PG&E also in 2020, the court approved third-party releases on a consensual basis. And in Midway Gold, that court, while it didn't approve third-party releases because it found it didn't have jurisdiction over the particular claims, it made clear that they would be permissible under certain circumstances. So what we have essentially is the majority of courts saying non-consensual third-party releases are okay under certain circumstances. And pretty much it seems every court says consensual releases are appropriate. But that then draws the question of what constitutes consent in this context. And that is not an easy question to answer, which is why I'm turning the tables back to Sam.
Thanks, Rachel. Thanks for giving me the big job here. Okay, so it's important to understand what is meant by a consensual third-party release and what is meant by a non-consensual third-party release, because often you don't really have a Chapter 11 plan that actually says, consensual. You have to go sort of read through many paragraphs and a lot of legalese to understand what they mean by a consensual release and a non-consensual release and a deemed consensual release. And often it's not in the Chapter 11 plan, but it could even be prior to the Chapter 11 process, which is the disclosure statement and balloting process, where the debtor requests approval from the bankruptcy court to solicit votes for the Chapter 11 plan. And typically in that process, disclosure statement process or the ballot solicitation process, the debtor will tell the world what their ballots look like and whether they are going to have releases in their Chapter 11 plan and who is going to be releasing and who is going to be released. So There have been different versions of these releases. And if you turn to slide 12, you'll see there are various ways where courts have in the past said that that these examples would be deemed consensual. For example, if the creditor or the entity votes to accept a plan, so there the entity or creditor made an affirmative statement by taking the ballot, and even though has not checked off a specific provision on the ballot that says I consent to the lease, to release, but rather only said I vote for the plan. Yes, affirmatively vote for the plan. That courts in the past have said that checkoff of voting for the plan means that they have deemed to consent to the release that's embodied in the plan. So that's an easy one. The second example of what courts have said in the past or debtors have proposed to be a consensual release is whether there are some times that creditors or entities in a Chapter 11 plan may not vote. And the reason why they may not vote is because they are deemed to be unimpaired under the plan, meaning that their debt will be reinstated, their claims will be reinstated, they're not going to lose, they're going to get the full amount of their claim through the plan. So the plan does not, the bankruptcy code provides that such creditors do not vote and they're deemed to accept the plan. So that's a second example of where the creditor has a chance to opt out of the release on its ballot. It'll get a non-voting opt-out of the release and then doesn't send that opt-out back to the debtor or back to the claims agent. And so those parties have been deemed to accept the plan and the releases embodied in the plan. The third example that you have here on slide 12 is silence. You haven't objected to the plan, you didn't vote to reject the plan, but you still have, you're also getting an opportunity to opt out and you didn't opt out, and that has been considered by several courts to be deemed consensual. The fourth example is not checking the box to opt out, even when you vote to reject the plan, or even if you object to the plan, but you haven't checked the opt-out box to opt out of the releases. Now that sort of is like an extreme version of a consensual, deemed consensual release. But the most, the way to get around this uncertainty is to have a plan where, in order to, or really courts are sort of heading in this direction, and Rachel's going to talk a little bit more about it in the new legislation and in the Purdue case, where you see courts are saying, I'm only going to allow a release where the creditor or entity or third party has affirmatively checked the box to opt in. Now, this difference plays out all over the bankruptcy, all over the place in the bankruptcy courts all over the United States. And in the Southern District of New York, you even have different judges within the Southern District of New York that treat these deemed consensual releases differently. You have Judge Wiles, who's in the Southern District of New York and does not allow any plans, would not confirm a plan that has an opt-out version of deemed consensual release, or even voting for the plan as a deemed consensual release. You must opt in. We had a case recently where the viewed software case, we were involved in that case. The debtor proposed a plan on the first day of the case and had opt-in deemed consensual releases in the plan. And guess what? They realized that Judge Wiles was appointed as the presiding judge on the case. And about a week or two later, they had to file a revised plan to completely reverse the engines and only have an opt-in, an affirmatively opt-in to the releases. You have Judge Glenn and Avianca Airlines recently approving. They're sitting in the same courthouse, but you get a different results. Well, now not during Zoom, but soon, hopefully. Judge Glenn approved opt-out non-debtor releases. Judge Bernstein sides with. He's retiring now, Chief Judge Bernstein, but he sided with Judge Wiles. And more, as Rachel will talk about soon, you'll see that the trend has been more of the opt-in version rather than the deemed consent version. Slide 13, I'll just spend a minute on slide 13, and you'll see you have the timeline of the releases on slide 13. Purdue files on September 15, 2019. By the way, if you Google articles prior to September 15, 2019, you're not going to get too many articles criticizing third-party releases. But Purdue came out. It's a very controversial case, a lot of claimants. Since then, there was a lot of discussion. The first plan came out on March 15th. July 28th, Senators Elizabeth Warren, Senator Durbin, and Blumenthal and Congresspeople Nadler and Maloney proposed the Non-Debtor Release Prohibition Act, which we're going to talk about in depth soon. Judge Drain confirmed the plan in September. There was additional legislation. And then December 16th, the District Court in New York reversed the Purdue case. And that was the first big reversal. And then less than a month later, and we're going to talk about the Ascena Retail. Ascena Retail is the entity that owned the Justice brand and some other brands, the District Court reversed the Bankruptcy Court's confirmation approval of the releases as well there. And then Rachel's going to talk about Delaware, which still kept the old releases, and we're going to talk about recent developments. But one of the effects of the Purdue case was, and we could go to slide 14, and we'll just talk a little bit about the about NERPA of 2021, which is the Non-Debtor Release Prohibition Act. And what it really says essentially is that all third-party releases are disallowed and prohibited unless the third party actually affirmatively, by a writing, a clear and conspicuous notice approving the release. And it can't specifically by law cannot be, that means the bankruptcy judge cannot approve a plan if the plan provides that these releases are approved by an entity that actually votes for the plan, no deemed consensual releases, failing to accept the plan, and most importantly, what it also says on the bottom of slide 14 is you'll see that the treatment can't be any different for a party that an entity or creditor that approves the release by this clear and conspicuous notice. So this is like the anti-death trap provision. A lot of you that are familiar with Chapter 11 plans know that death traps mean that creditors or classes of creditors that accept the plan and vote to accept the plan get a little bit favorable treatment. There's a lot of controversy on that, but by and large, courts have approved such plans. But here, this legislation makes it specifically prohibited to treat any creditor that has not specifically opted into the release any different from any other creditor. And Rachel is going to talk about the impact of this new legislation and other key provisions of this new legislation. Go for it.
Thanks, Sam. So as Sam discussed earlier on in this presentation when discussing third-party releases, there are a lot of benefits to them for bankruptcy cases and for the resolution of mass tort cases in this country. There was a marked shift from class actions still exist, but bankruptcy really affords a kind of a singular opportunity for parties to come together and create a solution for very complex, unwieldy problems. And the potential impact of this legislation by barring non-consensual third-party releases is that those types of releases are a real incentive for all the stakeholders involved in these types of global settlements. If you're a plan funder, your incentive to fund a plan, if you're still have the risk of liability hanging out there, is severely undercut. Requiring the express opt-in also undercuts the ability to deal with potential future or unknown creditors. So in the asbestos context, you're allowed to have those types of claims released and channeled, but outside of that, you wouldn't be allowed to do that, because how could an unknown or future claimant ever opt into a release? There's just simply no way for that to happen. So that means that those parties engaging in these types of settlements in bankruptcy would be left with that potential exposure hanging out there. It's a real uncertainty that will really undercut the value of these types of settlements for all the people involved. And another key issue with this legislation is that it severely undercuts the bankruptcy court's discretion to assess proposed plans and determine whether what's before them truly maximizes the benefit to all creditors, which is the true purpose of bankruptcy, is to maximize the recovery to creditors and to ensure that companies that are seeking reorganization are able to do so, able to continue to operate going forward, to fund these types of settlements going forward. And essentially this legislation says, nope, you got to fit it into this very narrow box. You have to get express consent, and it's simply not feasible in a lot of cases, particularly in the opioid cases. Purdue Pharma, the number of potential claimants is incalculable, right? So how are you going to really feasibly ever get express written consent from everyone whose claim is going to be released and channeled? By the same token, how do you give them conspicuous notice? So there's a lot of real practical implications to this legislation. It makes sense why some people were up in arms, as we'll get into the details of Purdue later, but unfortunately, taking this sledgehammer to the fly is going to cause problems for bankruptcy cases going forward if it is ever enacted. At this point, that's not clear that it will, but time will tell. So with that, I'm going to turn to a couple other key provisions from the Non-Debtor Release Prohibition Act. Sam addressed earlier exculpation clauses. This act would limit those releases for those who participated in the bankruptcy in some way to only those who were expressly retained by the bankruptcy court. So parties such as indenture trustees or plan funders who are never formally retained in a bankruptcy case, but are vital in so many cases, would be left without this protection, thereby undercutting their incentive to participate in the first instance. So again, we're having this unfortunate consequence of trying to find a solution where there might not really be a problem. Another key point in this legislation relates to the automatic stay, which is a well-known tool in bankruptcy. When a debtor files, they get automatic protection from all claims, causes of action have to stop. That protection does not extend to third parties unless the debtor goes before the court and asks that it be extended to non-debtor affiliates and others, because it would impact the debtor's bankruptcy. So a clear example of this is the Purdue Pharma case, where within days of the commencement of that case, the debtors came before Judge Drain and said, we need to stay all litigation against us, all non-debtors, the Sacklers. That way we can all come to the negotiating table, have some breathing room. We're not distracted by all of this litigation in state and federal courts across the country, and we can focus on achieving a resolution. And they were able to do that. That case filed in September 2019, and the plan wasn't ultimately filed until March 2021. Notwithstanding the fact that many of these parties had already been in discussions, and there was already kind of in the works this notion of having a global settlement like what we ultimately had in that case. Required almost a year and a half in bankruptcy to achieve. 26 orders from Judge Drain as recently as last week, further extending the stay to allow the time to achieve this resolution. This legislation would limit the stay extension to non-debtors to 90 days. So try to imagine in a complex case how you achieve a global resolution in 90 days. It's even in a simple case, that's a stretch. It's just simply not feasible in bigger, more complex cases. And again, you've got the exception of you can do this, you can extend the stay to non-debtors for longer than 90 days with express consent of the affected parties. I'm not sure how you feasibly get the consent of potentially thousands of people who would be affected by this. It's just simply not feasible in these bigger cases. And finally, one more point on this legislation worth noting is that if it is enacted, it would be immediately applicable to all pending bankruptcy cases. It would not affect final orders, but bankruptcy court orders don't become final until 14 days after entry. So
If they're not appealed, if they're not appealed,
and there's no stay pending appeal. So there is always that chance that an order is entered, and then before it becomes final and non-appealable, this act goes into effect, and then the order's kind of in limbo if it contains a non-consensual third-party release. So that it's really has the potential to have severe impacts on pending cases and future ones going forward. All right, so with that, we are going to turn to some of the recent decisions that were highlighted at the outset that are kind of squarely taking on this issue. Sam?
Right. So the first of the cases is Ascena Retail. Ascena Retail was an entity, a specialty retail apparel. They had 2,800 stores in the US and Canada. And they really, they included the Ann Taylor brand and the Justice brand, the Catherine's brand. It was a pretty consensual case, except that there were securities claims against the officers and directors by there was a class action that was filed. There was lead plaintiffs that were filed pre-petition against the officers of directors for some securities violations, securities fraud violations, and so on. But among the major constituencies the committee, the debtors, the lenders, the pre-petition lenders, and so on. It was pretty consensual. What the debtors did was sold all of their brands and accumulated about $650 million to pay creditors. And there was not too much left for the securities plaintiffs. And there were releases. And there was thousands of plaintiffs. And so there were thousands of these plaintiffs, and the Chapter 11 plan and Ascena Retail provided for broad releases and broad releases to many parties, and those parties, professionals, and pretty much that the securities claimants would need to opt out of the release. So you were in a situation where the debtor had to solicit and send ballots to many different entities, and they had to send ballots to people that own stock in Ascena Retail pre-petition, and to the owners of record. And what did you do about the beneficial owners of this stock, which was a real problem to do, to go ahead and but you did send the ballots for them to opt out, not opt in, but opt out. If they didn't opt out, they were deemed to have consented to the releases. When we get to we could talk now about the district court. One of the critiques of the district court that vacated the confirmation order, the bankruptcy court's confirmation order on appeal, was that that number one, the number of opt-out ballots supposedly went to 300,000 parties. Supposedly, the claims agent said that they sent out 300,000 ballots. And guess what? Only 0.2% of 1% of the ballots came back opting out of the releases. So that was one of the critiques. Another one of the critiques was that the Ascena Retail, the bankruptcy court did not really check the box of the First Circuit case that Rachel talked about, the Berman case, that has to be substantially related. It could be an indemnity issue or something like that, to be able to get the release. And the district court in the retail vacated the order. And what happened was the district court vacated the order on January 13th. There was no confirmation order. So picture this, the plan of everything was in limbo in between until a new order was entered. So for example, our client couldn't get our claim resolved and couldn't talk to the plan administrator because the plan administrator was only appointed pursuant to the old confirmation plan that was issued by the bankruptcy court in 2021. Finally, on March 3rd, 2022, which is just a couple of weeks ago, actually, no, 7 days ago, last week, the bankruptcy court confirmed the debtor's plan, but they had to reissue the plan. The confirmation order completely stripped third-party releases and severely limited the exculpation clauses. Rachel, I think you're up.
Yes. Thank you, Sam. Now I'm going to try to briefly discuss the Malinkraut decision that came out Delaware just this past month in February, bankruptcy court level decision. Malinkraut is the manufacturer of generic opioids and a variety of specialty drugs, and it ended up in bankruptcy after facing an onslaught of litigation for both the opioids and those specialty drugs. Its plan, like so many before it, contained broad releases. There were two that were subject to pretty significant opposition. One was third-party releases for non-opioid claims, These releases were pretty similar to those found in the Ascena retail case that the District Court of the Eastern District of Virginia had just found to be impermissible. Delaware court said, yeah, we acknowledge that decision happened, but we disagree. These releases are appropriate and they're consensual because consent was shown by either voting to accept a plan, being unimpaired and deemed to accept the plan, or abstaining from voting and not expressly opting out. We had a deemed consent case just last month in Delaware, and it was A-OK. There was also the opioid releases. So these releases are non-consensual releases of these opioid claims because there wasn't even a bar date for the opioid claims in this case. Rather, notice to these potential creditors was given through a massive campaign of media, direct noticing, and community outreach. The court concluded that was sufficient to satisfy the due process rights of these creditors whose claims were going to be extinguished as to a variety of third parties, many of whom never made any contribution to the bankruptcy case, and instead channeled into a trust. I believe it was approximately $1.75 billion to address these claims. The court concluded that was sufficient, just a broad noticing campaign, not actually having any filed claims. And the court concluded that the releases were necessary in this case, that the reorganization hinged on these non-consensual third-party releases. So it said, I'm going to confirm this plan, which it did. The order has been appealed. As of right now, it's been appealed by 3 different groups of people and entities, none of which have raised the issue of releases, but the confirmation order itself has been re-entered on the bankruptcy docket, I believe 3 times for technical modifications, which in turn has restarted the clock for filing a notice of appeal. So as of today, parties have until March 16th to file an appeal with respect to this confirmation order. And we suspect that the United States trustee is going to appeal the order because they raised the same issues that they have been raising and vocalizing in Purdue. So, and with that, I'm going to turn it back to Sam and our final topic, Purdue.
Okay, thanks, Rachel. So Purdue Pharma, I'm sure everybody has seen, the news reports about Purdue, the Sackler family, the opioid epidemic, and so on, which pre-existed the COVID epidemic. But anyway, so what I would just want to say is that the case was filed in White Plains, as many cases are filed in White Plains because of the bankruptcy judge there. Judge Drain has been on the bench since 2003. That's a long time, and and he is well regarded, popular, practical, and thorough. Unfortunately, I'm not sure, as a result of the Purdue Pharma case, he announced his retirement. I'm not sure, Rachel, if you remember when he's going to be retiring. But anyway, every one of his decisions is thorough, well-reasoned, and he's regarded as a judge that listens to both sides, and is a popular judge, as I said before. But Purdue filed in White Plains, and I guess the initial message was that the Sackler family was going to fund a plan to pay claims. And you could read the allegations on slide 22, whether you believe them or not. The Sackler family and Davis Polk probably have a different view of some of those allegations. But let's get to
I'll just note for the record that they're part of an uncontested record on appeal. So
Okay, okay.
Just gonna lawyer you on that one.
All right, okay. Oh, you mean some of the allegations, you mean, Rachel, right?
Right, they're not allegations, they're
Yeah.
acknowledged.
Well, my previous firm did a lot of the tax work, so I'm not going to say anything bad about the Sacklers now right now. But anyway, let's get to slide 23 a little bit, and then we'll talk about what Rachel mentioned before, that there was an injunction. Judge Drain issued an injunction that you were not allowed to continue any of litigation against the Sackler family, and it's now extended to March 23rd. And if the Second Circuit, we're going to see soon that you're going to see that the Second Circuit is not going to issue its decision by March 23rd, and we're going to see another extension of this injunction by Judge Drain for another 2 months. I don't know why he only does it only about a month or two, but he should go. He should actually extend it a little longer. But anyway, there was $4.5 billion. And the bankruptcy concluded, just like Malinkraut, that that the settlement was the best result under the circumstances. Of course, Judge Drain wasn't happy about the claim, the claims and the injuries of the claimants. He was very sympathetic to them. But based on Second Circuit framework as he read it, which was the earlier case, the Metro Media case that Rachel mentioned earlier, there was a basis to approve this type. This is not the first time that the tort 524G channeling injunction result in a Chapter 11 plan has been approved. There were hundreds of such of cases that were approved since then. So Judge Drain didn't really, and the bankruptcy bar did not think that this was so out of the ordinary. Anyway, so Rachel, let's talk about the appeal and where we are on Purdue.
All right, so in December of last year, the Southern District of New York District Court Judge McMahon entered a decision, very lengthy decision, vacating confirmation of Purdue's confirmation order. The court did believe that it had jurisdiction, the bankruptcy court had jurisdiction to adjudicate these claims, but the court concluded after a lengthy survey of the bankruptcy code, decisions across the country, and a review of Judge Drain's confirmation decision, that the bankruptcy court did not have statutory authority to authorize non-consensual third-party releases. Judge Drain had relied on his inherent authority to authorize those releases, but most courts, including the Supreme Court, have said that that inherent authority must be within the confines of the bankruptcy code. Judge McMahon reviewed the code and found that there were no provisions that expressly allow third-party releases, as we said at the outset of this presentation. Rather, you have Section 524E that says discharge of a debt of a debtor does not discharge the debt of another entity. And then she really focused in also on Section 524G, which does allow non-consensual third-party releases in asbestos cases only. That provision was enacted almost 30 years ago, and Congress hasn't acted to expand its scope or add any new provisions that would allow similar channeling injunctions in other mass tort cases. So to her mind, that was a clear indication that Congress does not approve of non-consensual third-party releases outside of the asbestos context. So with that, she said, nope, we're vacating this plan. Obviously, the debtor in Purdue has appealed to the Second Circuit. Briefing is set to conclude March 28th, and oral argument will be scheduled at the end of April. As Sam mentioned, as you may have seen in the headlines, there was a new settlement reached just last week where 8 objecting states and Washington, D.C. achieved a new settlement with Purdue that upped the contribution of the Sacklers from $4.5 billion to at least $5.5 and up to $6 billion. That new settlement was actually approved over vociferous objection just yesterday. A lot of the states that were okay with the original settlement weren't happy that these other states were actually getting an extra slice of the pie as part of the settlement. And the US trustee was also once again jumping up and down that you're not allowed to approve non-consensual third-party releases. Judge Drain said, be quiet, signed his order, hit the docket this morning.
I'm going to interrupt here to ask a few questions. And the first one, I guess, Sam, I'm primarily looking to you. There's been a lot of discussion about a channeling injunction. And my very limited understanding is that that's something that is used in civil litigation to bring about settlements. Could you give us a little background on where the channeling injunction came from and what the requirements are outside of the bankruptcy context?
Well, I mean, outside this started with the Johns Mansville case, right? It was a bankruptcy channeling injunction. You're right, Tom. This is outside of the bankruptcy context as well. That there are channeling injunctions. That people in the class action context that you need to look at a specific pool. That's the class action context has been around for many, many, many decades, as far as I can remember. It had to be, you had to bring your suit through the class action, and you had to get you recovered through the class action. So that's kind of the basis for what Johns Mansville did in the 80s. It's interesting now with the appeal. I just want to just address something that Rachel just said, is that if you take a look at slide 25, take a look at who's filing the amicus to approve the releases. It's the New York City Bar Association, which is not just your plain vanilla bar association. It is the oldest bar association in the country and most prominent. Minnesota, I live in New York City, and also the American Bankruptcy Institute. And so they are joining the appeal to the Second Circuit to allow these releases to be approved. But I don't know if I answered your question, Tom, but I hope I did.
I'll move on to the next one. And this one, Rachel, I think is for you. The district court in the Purdue case appeared to rely on a negative implication from 524G to disallow the third-party releases. Is this the only court that has used the negative implication, or has that been used in other decisions which limited third-party releases?
I think most courts look primarily to 524E, which is the one that just broadly says that the release or discharge of a debtor does not discharge the debt of a third party, to say that's really the extent of the discharge of debts in bankruptcy, is it's really just limited to discharging debtors. I think this Purdue decision is the one that really dug into 524G in extensive detail.
But it's an outlier, right, Rachel? Because look at Boy Scouts. Boy Scouts is now going to confirm, and it's a mass tort.
It's also in the Third Circuit, where we just had Malinkraut.
It's outside. It's in the Third Circuit, but it's not in the asbestos context.
Right. No, the reality is these have been approved up and down the board. But it's just kind of the tide seems to be shifting a little bit. And I think the optics of Purdue Pharma are a really big factor in driving this change, unfortunately.
So if anybody on the Zoom wants to join us, we're going to go to the Second Circuit. When is the oral argument, Rachel?
It's going to be scheduled week of April 23rd. I don't believe that there are set dates yet.
Oh, so April 23rd, we're going to know when it's going to be scheduled.
I believe so.
Okay. Okay.
Final question. Senator Warren got her publicity with the NRPA of 2021, which of course didn't happen. Has there been any talk about expanding and refining this concept through an amendment to 524G that would seek to limit this to where it is appropriate and to parties for whom it is appropriate, but not just say you can't do it?
Right. So there's no formal proposal in legislation for that. Since Judge McMahon's decision, you'll see articles all over the place that ought to be the practical resolution to this. That you'll get pushback from some of those proponents of NERPA of 2021. Yeah, Tom, that would be the reasonable outcome to this.
Nothing's been introduced though, or is there anybody in Congress talking about this or anyone looking at it? Like
not that I know of. If anybody on the call knows anything about it, please put it in the chat. Nothing that we've seen out there.
I think Congress has been a little distracted with other things these days.
Yeah, that happens.
Yeah. They're looking at student loans, which are near and dear to my heart. Yeah.
That's another topic that needs to be looked at.
Right.
All right, thanks. Those are the questions.
All right. Anybody who has any questions or wants to reach out to us in the materials, you have our email addresses or our phone. Please pick up the phone, call us, call Tom, Rachel, or me anytime, and we'd be happy to have a more longer discussion about this or any other topic. Thank you very much, everybody, for attending. Appreciate it.
Thank you.